Well, hello everyone. How are you? I hope you are doing well this evening, and welcome to 1111 True Crime. We are going to be that. I have got Jack Russells. I call them my little velociraptors. You may hear them in the background. They are good boys, though. Hi, Rose Hyde. Hello, hello. All right, my loves. We are going to get this rolling tonight right away. Let's get that up on the screen. Hi, Lorna. Thank you for joining me. Let's get a 1 if you can hear me loud and clear. And let's switch over to the browser and give me a 1 if you... Hi, Joyful. Well, what a joy to have you along for this reading. All right, my love. We're on page 36. Give me a 1 if you can hear and hear me and see the filing. Hopefully the boys calm down. They're just playing. Hi, Tracy Gear. Hi, Tammy Moss. I always have a hard time with your last name. Tammy Mostapa. I hope I said it all right. Hi, Jeff. Hi, Sarah. All right, you guys, I see that you've got a 1 on the board. We're going to jump right in tonight. I want to get as much ground covered as possible. We are starting, second paragraph on page 36. Let's take a second, get our whistle wet. Hi, Karen Guy. Okay. You guys ready for this? We're digging deep. Now, after we're done with reading our filing, which is going to take several times, probably, I'd say 1 more time after this, maybe, then we're going to get into getting into the case itself and kind of get everybody on the same page as in where you are and what you know about the case. We have some people that are diehard Stephen Avery supporters from the get-go, and then we have others that are just starting with us, and we want to make sure everybody is able to kind of like have the same language of what is going on. And so after we get done with all this reading of the filing, and in the near future, in the nights to come, we'll begin to have because I decided this is our Stephen Avery series, okay? Now, eventually, I'm going to have to break down and go watch Candace Owens' bullcrap and see what she's saying so that I can come back with a debate and be like, okay, what she said is this, and this is how I feel, or this is what I know, and we'll get into that. But I feel like, why should I go do that on a different channel when we can get everybody over here? This is a true crime channel anyway. And so this is kind of like our sidekick job here, in the sense of I can never ever give up on Brendan Dassey or Stephen Avery because I know the truth. And so I am a truther. I am a non-guilter. I believe that Stephen Avery was absolutely set up. And we can get into what do you believe as we get into our discussions. All right? Did I hear those 3 men frozen outside after the football game? When? 3 men frozen outside after a football game. I did hear something vaguely about it, like 1 on the porch and 2 in the backyard or something. That would be, I don't want to use the word fucked up, but damn. Okay, let's get into this. Hi, Cynthia. We are all adults here. It is adult content. Trigger warning is the goat. The goat is Billy, and he screams. So when I say trigger warning, you're going to hear a scream. That is not me. That is our mascot. And I'm going to start tonight off because I got a couple people that weren't expecting this filing to go into such detail, I guess, and they weren't prepared. So let's get ready, countdown to a very loud noise if you have headphones on. This is going to be a very loud scream. This is Billy the Goat. 3, 2, 1. And with that, contrary to the circuit court's view, the proper standard does not require Mr. Avery to establish his evidence of Bobby's motive with absolute certainty. In fact, This level of certainty has never been required by any court in Wisconsin to satisfy the motive element of Denny or any element of the Denny analysis for that matter. See State versus Knapp, where the Wisconsin Supreme Court has even deemed hearsay evidence as permissible evidence for satisfying all three prongs of the Denny test, including motive. Under the motive prong, the court simply must question whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime. Let's reread that, you guys. Under the motive prongs, so when they say prongs, you guys, it means criteria, all right? So Denny law is set up with three prongs, three criteria that must be met to be able to point to a third party. Do they have a motive or a suggested motive? Not are they guilty of it. So I explained in my personal view. Now, I'm not a lawyer, I'm not a doctor, I'm nothing but a mom, all right? Let's just leave it at that. But in that, I even understand that I don't, okay, if how do I want to put this? Okay, so I used an example the other night. I'm going to use it again. So we'll say this guy has a heart attack and he almost dies, and the surgeon that operates on him ends up doing something wrong, but the guy lives. So the guy turns around and sues this doctor in this theory. And then he has a second heart attack and he's in the ER, and the only doctor that would be available to operate on him is the doctor he is suing. So whether the doctor actually has an ulterior motive and bad feelings does not matter. It is the mere fact that because this man is suing him, he is, unfortunately, has a, quote, motive, even if this man would never harm an individual intently. So just because someone has a motive doesn't mean they're guilty, doesn't mean they did it. It means they would have a reason to do it. Okay? So that's all that needs to be established, is a reason for Bobby to do it. We don't need to prove his guilt. That is not our job, to prove someone's guilt. We aren't even inside a courtroom yet. We're still on paper. So that's her point. And so when they say prong, think of it as a reason, okay? Under the motive prong, the court simply must question whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime. Boys, can you go night-night, really? I know you're having a good time, but the rest of us gotta listen to it. They're looking at me like, what in the world's wrong with you? Because I never asked them that, but they stopped. Okay, go night-night, take a nap, so we can hear. I wish I could show them to you. They are hysterical looking at me, like a dead silence, just staring at me. Okay, let's continue. Where does this pick up at? We'll start here. Evidence of a general motive is sufficient to prove this prong of the Denny test. Forgive me. Further, because motive is never an element of any crime, and the state never needs to prove motive, relevant evidence of motive is generally admissible regardless of weight. Okay, I've got to reread that. That is quite a statement. Further, because motive is never an element of any crime, and the state never needs to prove motive, relevant evidence of motive is generally admissible regardless of weight. I did not know that, you guys. I learned something today. Sarah says, I love goats. I used to have milk goats. That's cool. All right, well, I learned something right there. Mr. Avery's third-party motive evidence is relevant regardless of the weight assigned to it by the circuit court. This is precisely in line with this court's prior guidance that if Mr. Avery's new direct connection evidence survives Escalona Navarra scrutiny and has merit, the motive evidence found in the Belly CD, quote, might become relevant to show Bobby Dassey's motive, and might bear on whether Dassey is or should have been a viable Denny suspect. Wow, that's beautiful, you guys. She's really doing a good job on explaining this. That is a paragraph right there that says so incredibly much. Moreover, the circuit court failed to consider the motive evidence, although not conclusive, in conjunction with Mr. Avery's new evidence, which establishes a direct connection between Bobby and the crime. Stop right there. So she's saying they did not take in consideration, when they made the decision, the other evidence that had accompanied it. So they just looked at it and they were like, all right. But they're not weighing in all of it that she's telling them, right? It's kind of like saying, well, I think the person is guilty, might be guilty because they had a motive to eat the cookies because they've been on a diet a long time and they were the only one in the room at the time that we know of. So whether or not the person ate the cookies isn't the deal. The motive stands on its own, that the person does indeed have a motive because they've been dieting and they were the only one in the room, cookies are missing. But if we weigh in the new evidence that that person was seen by someone like with an empty cookie jar in their hand, well then that's a whole new ball game, right? It should be looked at together, unless you're in kindergarten and you don't know how to do that yet. Mr. Avery offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Miss Halbach's murder and the framing of Mr. Avery. Evidence of motive that would be admissible against a third party, where that third party, the defendant, is therefore admissible when offered by a defendant in conjunction with evidence of that third party's opportunity and direct connection. In rehashing the weight of Mr. Avery's prior evidence of motive contained on the Belly CD, which this court already assessed was not sufficient in and of itself, but could be relevant if Mr. Avery could also show Mr. Dassey's direct connection. All right, so the court has said, okay, the kid was heavily into porn, and if you can show a direct connection between him and the crime of this victim, it could be very relevant. But just on the fact that you have Bobby Dassey's computer filled with porn and these 7 CDs that Mr. Factbender had in his own possession, the one CD that was suppressed, in his own little jewelry box and his nightstand at his house, talk about messed up case, okay? Well, we just told you. Now we got Bobby Dassey, according to the affidavit by Zawinski, pushing the vehicle of the victim. That's pretty damn much a direct connection. So it leaves them in a place where if you're playing tic-tac-toe, there are no more boxes to mark. We got the tic-tac-toe. We met the prongs of Denny. We met the prongs of Edmondson. We've met the prongs of whatever. Let's move on and get a damn evidentiary trial, right? Right, Sarah? He had the card, didn't he? All right. It does sound kind of kinky, Laura. Lorna said it sounds kind of kinky. All right, I got to get comfortable in my chair. Sorry if it's squeaking. Here we go. Let me back up a little bit because I like, it's a really run-on sentence. In rehashing the weight of Mr. Avery's prior evidence of motive contained on the Belly CD. Now that's with all the porn and the mutilation of the girls and all that. All the searches, right? Which this court already assessed was not sufficient in itself, but could be relevant if Mr. Avery could also show Mr. Dassey's direct connection. The circuit court evaluated the CD evidence in isolation, contrary to this court's prior directive in remanding the case. See Wilson, where the Wisconsin Supreme Court determined that the strength of proof of one of the reasons, right, may, quote, affect the evaluation of the other prongs. Naturally it would, right? Here, Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all three prongs of the Denny test. For example, even if the motive for Miss Halbach's murder was not sexual as law enforcement believed, the Zawinski evidence offers evidence that the motive could have been robbery, right? The circuit court's finding that Mr. Avery has not established, quote, the motive element is at odds with Wisconsin case law. Wisconsin cases that discuss the motive element of their Denny analysis show that the standard for fulfilling the motive element of Denny is not overly burdensome, especially when there is strong evidence of a third-party perpetrator direct connection to the crime. For example, State versus Ramsey is a case in which very weak evidence of motive against a third party was presented by the defendant. However, the appellate court found that there was strong evidence of a direct connection, and thus it found, quote, plausible reasons for the third party to commit the crime. In Ramsey, the victim was found stabbed at home. The 911 caller told police that the victim had been staying at her sister's home to hide from the defendant. The defendant had been in a relationship with the victim for over 11 years, and they had 2 children together. They had a history of domestic violence. Officers found the defendant, and the defendant admitted stabbing the victim twice. The victim's best friend told police that the day before the stabbing, the victim told the defendant that she was going to leave him. After fingernail clippings from the victim revealed another man's DNA, the defendant brought forth a Denny motion arguing that the potential third-party perpetrator, 1, was a convicted criminal, 2, lived near the crime scene, and 3, his DNA was present at the scene and is unexplained. The defendant alleged 2 possible motives for the third-party perpetrator: irrational rage and antisocial behavior, or sexual gratification. The defendant argued that it was possible that the third party had no rational motive. Thus, the defendant presented evidence of a general motive which was not directed at a particular victim. In Ramsey, the circuit court found that the defendant had failed to establish the third party's motive and denied the motion. However, the appellate court reversed the circuit court's ruling, stating, "We conclude that when considered under the applicable law regarding motive and with the opportunity evidence and the strong direct connection evidence, Ramsey had presented plausible reasons for third party to commit the crime." The appellate court found that, quote, under the totality of the circumstances, the evidence suggests a third party perpetrator actually committed the crime, emphasizing that suggests is a rather broad term. Here, Mr. Avery has presented far more evidence than is even required to suggest that the third party actually committed the crime. The circuit court's failure to consider the Denny prongs in the ag right and its erroneous imposition of a burden of substantial certainty on Mr. Avery's motive evidence results in a fatally flawed opinion on the law and the facts. How are you guys doing? Jersey Gal, hello, lovely. Very sketchy. 3 men found in a backyard after a Chiefs game. I heard about that, you guys. We'll have to look into that. Lorna says, a lot of motives don't seem to be rational in my opinion. I agree. I agree. All right, lovelies. Number 3, opportunity element of Denny. In regard, wait, let me wet my whistle. I'm going to pause for a minute. Gotta get ready for a big read. Number 3, opportunity element of Denny. And I want to thank you all for joining me tonight. In regard to the opportunity element of Denny, the circuit court stated in its opinion that, quote, even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test. I'm going to go like scream. All right, you guys, if you're on headphones, it's a goat moment, and you're going to hear a loud scream. So brace for impact, because I can't. All right, I feel a little better. Let's reread that. Even if the defendant had met the burden with respect to the motive, which was their big bitch before, he has not met the burden with respect to the element of opportunity under the same test. Opportunity? How would Bobby Dassey not have a fucking opportunity? Oh my God. He himself on the stand admits he was the last one besides his uncle Stephen Avery to be on that property at the Stephen Avery Dassey residence alone with the victim. Why would we have to prove opportunity? Oh my God. I'm choking on the bullshit. Oh, it's so thick. Karen Guy says, finally someone in the judicial system with common sense. All right, let's do this. It is undisputable that Bobby was on the Avery family property when Miss Halbach was there. And before and after she was reported missing. What did Zellner call it? Silent rage? Okay, normally even proximity to the murder is sufficient to show opportunity. I'm going to say the most vulgar thing I've ever said on YouTube in my life. What the hell do they need? Him changing her tampon? I'm just saying. How close does he need to be? 2 days, the girl is completely missing. We have an eyewitness validating that Bobby Dassey is pushing her car. Her car contains her blood, y'all. Her blood. The only blood in this case is in that damn car. There is no blood anywhere else in this case but that car. He's got possession of it. What the F are they talking about? Opportunity. This is because Wisconsin gave away the damn bones. Wisconsin did this. And they showed their ass. And so now we're in word salad fight. They're going to play dumb. It's like, we're going to play like we're really fucking stupid and we don't know. And that way we can just be like, you didn't say that the balloons needed air in them to float. Oh, we got to put air in them? All right. However, the circuit court improperly imposed a burden on Mr. Avery to prove that Bobby had the skills, contact, tools, time, and or other means necessary to have committed the crime and staged the scene in order to satisfy the opportunity element of Denny. The circuit court cited State versus Wilson for its own findings that a Mr. Avery has to prove that the potential third party had the skills, contract, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner alleged. However, in reality, this principle came from the Kansas Court of Appeals case that the state cited in its response brief. Even if the principle from the Kansas case were to somehow apply to Wisconsin, the facts of Kreider are completely inopposite to those in Mr. Avery's case. In Kreider, the defendant's pro-offered evidence of a potential third-party perpetrator consisted of alleging a potential motive for the victim's son-in-law to kill her, in that the son-in-law's wife would benefit from the inheritance, and that the son-in-law could have had the opportunity to get the defendant's hair from headgear and blood from used bandages to later plant at the crime scene while staging there overnight, because he worked as a first aid officer at the defendant's work. The court found that the evidence did not effectively connect the third party to the crime, stating, "This evidence is nothing more than mere speculation and conjecture, and does not connect the party to the crime, and therefore the district court did not err in excluding it." All right, pause right there. You guys, the rapport that we've never seen, that we'll never see, that, left the Avery property locked, that nobody, not even God himself, could get into, and arrived at the state crime lab with the driver door unlocked, that rab, that is the largest piece of evidence and contains 90% of the evidence in the case. So you cannot say that Bobby Dassey having possession of that said vehicle is not a direct connection to the crime. You cannot say that. Rather than considering that this principle came from a Kansas case, not a Wisconsin one, the circuit court imposed a burden on Mr. Avery to demonstrate that Bobby had the, quote, scientific knowledge to plant evidence. Okay, hold on a minute. Are you trying to tell me that the state of Wisconsin thinks that you have to have some sort of scientific knowledge to plant evidence? Are you a Q-tip? A Q-tip where there's fresh blood in the sink? And then you take it and you wipe it on a dash of a car? What kind of law degree or bachelor's degree do they think we need for that? I mean, there was dust all over Stephen Avery's home. He was not a duster. Sure, he was organized, but he wasn't like a clean freak. Dust everywhere. You can't clean up DNA and leave dust. It doesn't work. That dust is a legal patina. Look it up. Legal patina is basically an organic environment that has been undisturbed over a time frame, which means you cannot clean up something without removing the dusty patina, right? So if Steve Avery did all this shit to Teresa and he had dust all over his house, he couldn't have cleaned it because the dust is still there. So where's the blood? No. Nay. The only blood is in the rab, in the back of the rab. And we've never heard that's Teresa's blood. Never once. We've only been told it matches the DNA of the person that drank out of that cherry Pepsi can. Huh. Talk about a bubblegum and horseshoe throw here. It's just crazy. Sarah Baggins says, yeah, isn't Wisconsin the cheese state? Yep. Cheese, beer, and brats. We're a German state. Joyful says, yes, it is. Wisconsin is the cheeseheads. Lorna, maybe they tore down and buried the RAV4. They crushed it into a little tiny piece of metal and they put it into... See, have you guys ever heard of the Sika keynote? I can't wait to get in this case with you guys. Have you ever heard in this case of the Sika keynote? Give me a 1 if you've heard of Sika key. Hey, Nine's Life. Well, the state thought the Denny suspect needed to be seen with the RAV key in his possession. So God knows what stupidity the state requires and thinks. They're going to have a picture of Bobby pooping out the key, right? Ah. Lorna says, do you mean like dropping a bullet or a knife sheath nearby? Yep. Sikiki, Nan's life has. That's right. So, for those of you unfamiliar with Sikiki, it was a note that was left in the Green Bay post office or just showed up somehow. And there are allegedly no fingerprints on it. And it was a little clue. It had Steve Avery's name on it. It has the Manitowoc County Sheriff's name on it. And it talks about it says something along the lines. Let's go look it up for a minute. Browser. Let's look it up. I should have typed Avery case first. I don't even remember how to spell it. Okay, images will pop it up. Here we go. Let's get over here. Here it is. Okay, this is one side of it. Here, this one's got both. Let's visit this site. Oh, look, you guys! It's on my own site! My rubber ducky. It took me to my rubber ducky channel. So you guys go watch the very first video I made right here 5 years ago. Rubber ducky. It's got 6.4 thousand views. Let's go here. I'll mute it so you don't have to listen to. Anyway, I've always thought they're talking about the car. I think they're talking about the RAV4. So it says body. Okay, wait. Let's get back. Let's get off this. I Googled it and got my own damn video. That is funny. All right. So I don't know how good you can see it over here. Let me see what you're seeing. You can see it. All right. Can I make it bigger? Not really, because it jumps off. Maybe. Oh, it made it smaller. Cheesy Louise. So it claims that the body was burnt up in aluminum smelter 3 a.m. Friday morning, Sikiki. And because it has the word key in it, I always thought that there was a key with it. All right. But they claim nothing was with it. I don't believe that. And I believe that this is talking about the RAV4. The real RAV. That was letting the sheriff know, because I believe that was the game plan. And it says body was burnt up in aluminum smelter 3 a.m. Friday morning. What do you guys think? I know, bubblegum in a horseshoe throat. I don't know where words come from. Sounds like a Happy Meal. So what do you guys think about that? You know, that's the note that was left. It allegedly has, you know, something to do with the Avery case because it's got Stephen Avery's name. Well, it says Avery on it, and it's got Manitowoc Sheriff, and it ended up in the case. It was suppressed for a while, but the defense found it. So let me know what you think on that. I just thought that was something to look at, but that is funny that it took us to my video. Okay, let's get over here. Let's close out these windows and let's get into it. The court found that the evidence did not effectively connect the third party to the crime, stating this evidence is nothing more than mere speculation and conjecture and does not connect the third party to the crime, and therefore the district court did not err in excluding it. Rather than considering that this principle came from a Kansas case, not a Wisconsin one, the circuit court imposed a burden on Mr. Avery to demonstrate that Bobby had the scientific knowledge to plant evidence. The facts of Wilson are completely in opposite to Mr. Avery's case. In Wilson, multiple eyewitnesses identified the defendant as a shooter. The defense attempted to argue that someone else was a shooter by offering evidence of an alleged potential third-party perpetrator. However, the potential third-party perpetrator was completely unknown, and because the defense's theory was that a hitman was hired by the man in the car with the victim to kill the victim, and then the hitman shot the victim. The Wilson court found that there was no evidence showing that the man in the car with the victim had the opportunity to hire a hitman in a brief amount of time. He was in the car with the victim before she was shot by someone else. The defense failed to present any evidence of contacts, influences, or finances used to hire a hitman to corroborate its hypothetical theory that the potential third-party perpetrator was some unidentified hitman. Thus, the Wilson court found that, quote, Wilson's pro-offer failed to demonstrate that the alleged assassins were anything but purely hypothetical people. Importantly, Wilson is not a case about planting evidence of framing. Wilson specifically stated that this type of theory only requires a showing of access to frame, stating the following. If the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. However, the circuit court erroneously reasoned that pursuant to Wilson, Mr. Avery must prove that Bobby had the, quote, scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by professional crime scene analysis. Hold right there, stop right there. What about the fact that on the Dassey computer that Bobby allegedly had access to in his bedroom, there is a file labeled DNA. There is a file labeled Teresa Halbach. There is a file labeled Steve Avery. I would like to know what is contained in the DNA file. And could that have been information that would, even though not required, satisfy the scientific knowledge? Huh? Just wondering. I mean, all he has to know is that he needs living blood, which, like it just got blood, not dried blood, and a Q-tip. I mean, it could be a damn sticky note in that file that just says, get real blood, use a Q-tip. Glove up before you do it so you don't leave your own DNA. Okay, where are we? This is not the standard for showing a third party framed the defendant. Evidence that the third party had access to the items used in the frame-up is sufficient pursuant to Wilson. Ultimately, the circuit court imposed upon Mr. Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. State versus Balbrecht is a case in which the evidence of connection and motive carried the strength of the opportunity evidence. The trial court granted the defendant a new trial, and the appellate court affirmed. Although the evidence of the third party's opportunity only theoretically put the third party in the geographical area of the murder of the victim, the appellate court focused on the strength of the evidence of motive and direct connection rather than opposing any higher burden to show opportunity, as the circuit court in Mr. Avery's case did. The facts of Balbrecht are similar to those in Mr. Avery's case, where in both cases the defendants were convicted based in large part on completely circumstantial evidence. In Balbrecht, the defendant was convicted of first-degree murder and first-degree sexual assault after a woman who had been shot in the back was found in a wooded area, naked, hanging from a tree by tire chains. The defendant had been with the victim the day before she was reported missing. He told police that he was dropped off by her, but detectives spoke to several people who knew the defendant and were in the area where he claimed the victim dropped him off, and none of them saw the defendant in the area. Police interviewed a witness who identified the defendant as the person the witness saw near the area where the victim's body was found on the day she was reported missing. Further, the defendant's hairdresser told police that the defendant talked to her about the murder investigation and told her that, quote, I didn't do it, and if I did, I don't remember doing it. A witness who lived near the area where the victim was found testified that he woke up and heard shots at 2:50 a.m. and the sounds of a car dragging, which then stopped. He heard it start up again 20 minutes later. His testimony was used to establish that the victim was murdered between 3:30 a.m. and the time which the defendant estimated he had parted ways with the victim. 20 years after his conviction, the defendant filed a Wisconsin Statute 974.06 motion for a new trial based on newly discovered evidence of a third-party perpetrator who had been convicted of a similar killing only 6 weeks later. The new evidence stemmed from the post-trial discovery of police reports, including information that the search of the third party's residence uncovered a revolver and books involving rape, chains, and torture. Notes about the third party's statements to co-workers about tying girls up, abusing them, and getting rid of them, and statements to inmates that the third party liked to chain and burn women. The state took issue with the opportunity prong of Denny being satisfied, noting that the third party lived 30 miles away from where the victim was found and also had killed the other victim 30 miles away. And it argued that the opportunity evidence must be more than just a theoretical possibility of the third party committing the crime. However, the appellate court rejected this argument and found that, quote, the record reflects that the post-conviction court's determination as to opportunity was made in light of the evidence presented as to motive and direct connection. We agree with the defendant that facts give meaning to other facts and that the significance of the third party's opportunity to commit the crime depends on his alleged motive and direct connection. In Mr. Avery's case, the opportunity element has already been decided previously by the courts. According to Mr. Avery's trial court, Mr. Avery's trial defense counsel already established that Bobby had the opportunity to commit the murder of Miss Halbach because of his presence on the property at the time Miss Halbach was there. Moreover, Mr. Avery's new evidence could not present a better case for showing a third party's access and accordingly evidence of a of a frame up. The Zawinski evidence greatly strengthens Mr. Avery's evidence that Bobby had the opportunity to commit Miss Halbach's murder because it shows that Bobby was in possession of Miss Halbach's vehicle, where her murder likely occurred. He had access to Miss Halbach's vehicle and all of the evidence used to convict Mr. Avery of her murder. Quote, if the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. Correctly applying Wilson, Mr. Avery had not only shown Mr. Dassey's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in the Denny case, State versus Wilson. It is not the circuit court's theory that guides this analysis. How are you guys doing? Lorna says, ignore the obvious, but go on this ridiculous theory. Yeah. Well, hello, Jennifer Swain. Oh my gosh. Hi, lovely. How are you? I have wondered so often how you are. Good to see you. Sarah Pagan says, that's true. I don't know what case you guys are talking about, but I see what you're saying, Lorna. Okay, you guys, here we go. Rather than accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant the evidence that he had access to in the vehicle. However, there is no hold on. I think she's about to be like, there's no scientific evidence needed to grab a effing Q-tip and collect blood and swipe it on the dash, right? However, There is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. Common sense would suffice. Hold on, you guys. Gretchen needs me. What you need, Gretch? What you need? What? I can't hold. Okay, come up here. Come here. I gotta hold my dog while I read, so it could be interesting. Hold on. Hold on. Okay. Otherwise, she's gonna fuss, and I don't want to end it here. So, woo, Gretchen, don't hit the keys. Okay. Okay. Here we go. However, there is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. Common sense would suffice. The circuit court did not explain what special skills it took to shoot Miss Halbach in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle. He had obviously pulled many triggers. In terms of planting the evidence with the blood, the only skill that would be required is taking a wet sponge and removing Mr. Avery's blood from his sink and dripping 1 to 2 milliliters into the RAV4 and applying it to the dashboard with a household item such as a Q-tip. Get down, Gretchen. Mommy is too excited. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31st, 2005, rebled on November 3rd, 2005, and dripped in his bathroom sink on the bathroom floor. Mr. Avery told law enforcement and his trial defense counsel as he was leaving the property on November 3rd, 2005, and exiting onto Highway 147, he observed taillights of the vehicle close to his trailer. Mr. Avery told his trial defense counsel he noticed the blood had been removed from his sink when he entered the bathroom earlier in the morning of November 4th, 2005. The bullet fragment. Are you ready? Aw, Seer says, I love the puppies. I do love Casey's sarcasm, Nan's life. Alright, here we go. The bullet fragment, you guys. Here we go. The bullet fragment, which Sherry Colhan, ruined everything about it, and yet they still used it. Okay. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Miss Halbach's blood or on her skin cells, both of which her murderer had access to before her body was burned. This court determined, quote, the state did not argue that this specific bullet entered Miss Halbach's skull or killed her. Wow. And there were no bone fragments on the bullet. It is undisputed that there were bullets all over Mr. Avery's property, from Raleigh Johnson shooting gopher holes with his .22 rifle, as well as Jody Sajaskowski firing it. This was the gun that fired the bullet that was found on Avery's garage floor with Miss Halbach's DNA on it. No skill was required to plant the electronic devices in Mr. Avery's burn barrel. The fact that there were burned barrels at the Dassey property, 4 in total, one of which contained human bones, shows that the Dassey, which includes Bobby, were proficient in burning material in the burned barrel. Part of the circuit court's interpretation of Mr. Avery's guilt is based on another factual error. It's believed that all of Miss Halbach's bones were found in the Avery burn barrel. They were not. They were found in the Dassey burn barrel, which I proved in a video long before this all came out. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a waft of flammable liquid or fluid, but did not smell burned rubber from tires, which the state claimed was the accelerant Mr. Avery used. Have y'all ever smelt burnt tires? It does not go away. It cannot be missmelled. If tires had been used to get this hot enough to burn a body right next to a propane tank, it would have blown. That little piece of cardboard trailer 10 feet away, poof, kindling. Dr. Eisenberg claimed that when... Okay, we did that. This evidence suggests Mrs. Halbach's body was burned in the Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggests that Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the victim's RAV4 in Mr. Avery's trailer between Wait. I'm going to reread that. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the victim's RAV4 in Mr. Avery's trailer between November 3rd and November 5th. There was no such argument made. Bobby would have had the key when he planted Miss Halbach's vehicle on November 5th, because it is undisputed the RAV4 was locked when it was discovered. Oh my God, yes. So whoever left the vehicle on the Avery property necessarily had the key and locked the vehicle. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5th, until shortly before noon, when the vehicle was located and the Avery property was secured by law enforcement. Boom! Mr. Avery and his mother left for their Cribbets cottage around early Saturday morning. That kind of sounded weird. She could have left out the around. According to the circuit court criteria, Mr. Avery was even less qualified to commit the murder than Bobby. By way of comparison, I was just going to go there. Lorna says, anyone who has ever watched TV or read books has the knowledge and skills to plant evidence. All right, lovelies. In terms of his education, he was less educated than Bobby. Never having graduated from high school, he was less skilled than Bobby because he never held a job because he was wrongfully convicted. Whereas Bobby was employed as a third-shift worker at a furniture factory during all the years Mr. Avery was incarcerated for his first wrongful conviction. Bobby had been honing his skills in stalking, hunting, killing, burning, and dismembering game. After misapplying Wilson, the circuit court erroneously presupposed that the forensic evidence against Mr. Avery stood up to scientific scrutiny in Mr. Avery's trial. Mr. Avery's defense team never presented the required experts to attack the scientific evidence. Mr. Avery, in his second post-conviction motion, presented voluminous evidence of numerous experts that the forensic evidence which was used to convict Mr. Avery was vulnerable to being discredited if the defense actually presented all of the experts that the trial defense counsel failed to present, such as DNA, trace, blood spatter, fire, forensic pathologists, and ballistic experts. This court determined, certainly, these conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial, but concluded that Avery's experts had failed to show how an introduction at trial could reasonably have led to a different outcome. Now, this court has a direct link between the third-party suspect and the forensic evidence. This court can consider Mr. Avery's forensic expert opinions in light of the identification of a third-party suspect in determining if this evidence could reasonably have led to a different outcome. For example, Mr. Avery's blood spatter expert described the blood pattern distribution in the vehicle as being inconsistent as coming from an active bleeder, as the state claimed. Knowing Bobby had access to Mr. Avery's sink with blood in it, and how simple it would be to selectively drip the blood in the vehicle, the court should reconsider the blood spatter expert affidavit. Mr. Avery's DNA expert described that in the controlled experiments he conducted with Mr. Avery holding the key for 12 minutes, there was 10 times less DNA deposited on the exemplar key than what than what was present from Mr. Avery on the vehicle key found in Mr. Avery's bedroom. The expert suggested that if the DNA on this key was enhanced, some personal item of Mr. Avery's was used for this purpose, such as a toothbrush, which, you know what, they collected. Oh yeah, they collected his toothbrush. Go look at the evidence files. Where is it now? Because we have it. We have a record that they state they collected his toothbrush for evidence. Why would his toothbrush disappear? All right, here we go. There was 10 times less DNA deposited on the... Okay. The expert suggested that if the DNA on the key was enhanced, some personal item of Mr. Avery's was used for this purpose, such as a toothbrush, a cigarette butt. Mr. Avery previously presented an affidavit that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. Told y'all. In regard to the hood latch swab, Mr. Avery is not abandoning his theory that the illegally collected groin swab taken from Mr. Avery were substituted for the hood latch swabs when they were delivered to the Wisconsin crime lab. However, for purposes of demonstrating that Bobby had the skill necessary to plant DNA on both the hood latch and Mrs. Buck's key, Avery asserts that Mr. Avery's toothbrush could have been rubbed on both. Bobby had access to the trailer where his toothbrush resided prior to disappearing. Alright, you guys, this is where we're going to leave it for tonight on the read. I'm coming up to top side. We'll just go over here and close our little browser, and we can chit-chat for a minute. Joyful says, I got cheesy poof chips. I'm eating. Anyone want some? And some cherry sour chewy candy. Joyful, I want to come over and have a sleepover. That sounds like so much fun. Sarah says, popcorn. Lorna says, kettle corn. Sarah Fagan says, yep, it's official. Bobby is sick and twisted. Sicko. So, those of you that are familiar with Summer Wells' case, put a 1. I have a reason. I have a reason for this. I want you to put a 1 if you're familiar with the Summer Wells case. So, oh my gosh. Oh, Jennifer Love, thank you for the snooper chat. We are all devastated at the loss of our beautiful Marie. I'm not trying to make this personal, you guys. I know, Gretchen, Mama's going to take you. I'm only going to be here on a minute or two more. Thank you, Jennifer, so incredibly much for that. But I want to say, Marie was one of my mods that sent me little emails that cheered me up, that just random little things that she colored for me. She would send me little things about the dogs, and it was always positive. It was always loving. It was always so kind. She was just always so cheerful, and I honestly, I was just so, I adored Marie a lot, and I miss her. I miss her so much. It sucked the wind out of my sail a little bit. I think that's a little bit of what's going on with the change on the channel. We lost Eric Cozy in the Steve Avery case, and it sucked the wind right out of me. I had to leave the channel. I tried to cling on and be like, okay, I'll carry the torch, Eric, but I couldn't. I couldn't at the time. I just felt alone. I know that we have a lot of family members. I do, and I know you guys are like, you're never alone, Mama D. You're never alone, RD. You're never alone. I get it. But when someone passes over, there is some grieving time that we have to go through. And I miss her terribly, and I know y'all do too. I know you do too. She was a true earth angel. With that, my Gretchen is crying, you guys. She needs her mama. She needs to probably go outside, and I'm going to get off here. I love you guys. Please swing back. We are on page 50, and we have a little bit more to go. And we will absolutely, Joyful, I would love to. Come here, Gretchen. Mom will hold you. Come here. Come here, old lady. No, she can't. She won't let me pick her up. She's got to go potty. I love you guys. Let's get our music going. We're going to close this down. I want to tell you, you guys are incredible for staying with me. This is just a case I personally can never walk away from. I will not. I will always see this case to the end. And so I respect you guys, even if this isn't your case, for coming over and supporting us and learning about it. We always want to share awareness. So we've got some big changes coming. I love you guys so incredibly much. I want you to think about this. Okay, Gretch, just give Mama a minute. I know you're not going to die. Give me a minute. All right, she's getting pissed at me. Here's the thing. I asked you about the Summer Wells case because when you're looking at Wisconsin, Summer Wells' Aunt Rose, okay, Aunt Rose went missing in Wisconsin. And they are circulating, at that time, they were circulating a flyer of a guy with the same tattoo as Mike O and Bobby D. And I have always wondered if they had something to do with Rose's disappearance, but they seem too young. So, my question is, was someone grooming these boys to be serial killers? Is there a groomer in the background that we don't know about that could have actually done Rose's kill and has the same tattoos? I'm just asking. I love you guys. With that, let's get our music started. Let's get the music up in here. I will see you all tomorrow. Oh, wait. I know. I'm like Columbo. I always come back. I'm like, and another thing. We do have a live tomorrow, and it is called Night Runner. So that will be happening, and then we will also go live with part 4 of our Steve Avery Kathleen Zellner filing. So, Night Runner tomorrow. I'm not sure if it's going to be a chit chat or an actual tarot reading. I'm waiting for the divine to tell me. I love you guys forever and ever and ever. Thank you, Jennifer Swain, for being incredibly supportive. I love you all, and rest in peace, Marie. We love you, my beautiful darling.